Welcome, everybody. I think we'll have some people joining us as we go, but we might kick off just mindful of everybody's time, making sure we stick to our time as well. So welcome again. My name is Alyssa Hall. I'm the Director of Practice Development at the National Centre, and I'm delighted to be with you this afternoon for this session. Before I introduce our partners in this work, I'll just do some acknowledgements and then we can keep moving through. I would like to acknowledge the traditional owners of the lands that we're all calling in from, the different lands that we're all calling in from today. So for me, it is Meanjin in the lands of the Turrbal and Yagara people. I'd like to pay my respects to elders past and present and extend that acknowledgement to any Aboriginal and Torres Strait Islander people who are joining us today. I'd also like to acknowledge the strength and the courage of people with lived experience of child sexual abuse, and really that we commit at the National Centre, and I'm sure collectively people on this call, we commit to working with victims and survivors and for victims and survivors to receive the support and the care that they need throughout their life. Just a reminder, I know many of you will know this, but a reminder that, today's session contains sensitive content. We know that child sexual abuse occurs in incredibly high rates in the community. And we know that includes in our workforce. And we also know there's a ripple effect in terms of the impacts of child sexual abuse, including to professionals. So we encourage you to please look after yourself. If you need to step away, please do so, and also reach out to the numbers or to your support network as needed. Just another kind of disclaimer before we get going, that there's just to call your attention to the disclaimer in the chat function, but just to remind people that the focus of this session is a legal environment and the legal process, but obviously this isn't legal advice. So you need to seek personal legal advice and professional legal advice as needed. So that disclaimer is just in the chat as a reminder. Another reminder, just to for those who don't know about us. So the National Centre for Action on Child Sexual Abuse. So we were founded in late 2021, and we are a partnership between three organisations: Australian Childhood Foundation, Blue Knot Foundation, and the Healing Foundation. We're really here for one reason. The National Centre really exists for one reason. And that reason is that 1 in 3 girls and 1 in 5 boys have experienced some form of child sexual abuse before the age of 15. That is our call to action. That is all of our collective call to action. So we have a singular focus at the National Centre on child sexual abuse. And our ongoing work really is about both focusing on the protection of children and young people from child sexual abuse, but also how we support better responses for adults who have experienced child sexual abuse. Thanks, Lee. I think we can move to the next slide. As part of the way that the National Centre does our work, we have something that's called a knowledge to action framework that underpins our approach. And it's really an articulation of the way that we think about knowledge. So we define knowledge to include expertise, experience, and evidence from different and interconnected categories and sources of knowledge. So they're here on your screen. So lived and living experience, cultural knowledge, research and theory, practice knowledge, and procedural knowledge. And for us, the real richness is around the notion of knowledge inquiry, but particularly knowledge synthesis, and how we bring all of these incredibly meaningful, useful, important sources of knowledge together to inform the way that we do our work. Thanks, Lee. And just bringing us to our session today. So as you know, the title of this session is Legal Insights, Guiding Adult Victims and Survivors Through Redress and Compensation. As you'll see on the screen, the bubbles identify the overview. Essentially, we're going to provide an overview of the National Redress Scheme, including specifically some of the key changes that have been made. The redress process and stepping out the application and the review process, and also methods to manage and support people through the process. And also we'll touch on support services, redress support services and other compensation schemes towards the end as well. Just to draw your attention that the Q&A will be open, and so you'll be able to post thoughts and feedback. We won't be monitoring the Q&A and responding to specific questions, but certainly feel free to use that to post thoughts and any feedback that you'd like. Okay, I'm delighted to be able to get going on this session. And before we do, I obviously want to introduce our partner in this session, which is No More. Many of you will know No More. So No More is a free national multidisciplinary community legal centre assisting survivors of child sexual abuse. They've got extensive knowledge and experience and expertise in guiding survivors through their options about compensation and through redress and other legal issues. They started working in 2013, giving assistance to people in relation to the Royal Commission into institutional responses to child sexual abuse. They are a free national legal centre. And since that time, No More has supported many victims and survivors of child sexual abuse. And I'm delighted to introduce from No More, Rachel Neal. Rachel Neal is our speaker with us today. She's the principal lawyer in the state teams at No More Legal Service. Rachel's worked with No More since 2019. Prior to working at No More, she was the principal solicitor of Women's Legal Service, Queensland, and held several roles there over an 18-year period, so a really long period of time, working in domestic violence and family law. She spent her legal career committed to helping vulnerable people to access their rights within a strong framework of trauma-informed practice. And I am absolutely delighted to hand things over to Rachel. But just before I do that, I really just want to centre us and ground us in a couple of comments. This session obviously will focus on the legal process of redress, but I really wanted to just pause for a moment and remind us that the purpose of redress is to recognise the harm done to people who have experienced child sexual abuse and holding institutions to account. And I also want to acknowledge that we know very well from victims and survivors that the scheme has lots of limitations and lots of challenges for victims and survivors of child sexual abuse, and that the processes and the outcomes that are delivered often from the process at times don't meet the needs and and expectations of victims and survivors. And I think it's just important to really hold that for a moment and remember that this is a scheme. We know that there are challenges to it, and that we really hold the experiences of victims and survivors at the centre of the way we think about the work. All right, fantastic. I'm going to hand over now to you, Rachel, to move us forward.
Thank you, Alyssa, and thanks everyone for coming today. I love talking about my work. But before I start talking about the National Redress Scheme, I just want to give an overview of the whole compensation and redress and recognition system, I guess, and how they intersect. It'll just be a short overview. But there are many options that people have, and so it's important to know what those options are. The first one that I'll talk about that you'll see there are civil claims. Now, civil claims are legal actions against an institution or a person for harm that is done to someone. And civil claims are about true compensation. Compensation, when we talk about it in this context, is compensation that's intended to put the person in the place financially that they would have been had the abuse not happened. With civil claims, there's no limit to the amount of money that can be awarded. While I say that they're court processes, they sometimes go to court and decided by a judge, but the vast majority of them are usually settled outside of court in a mediation, but it is still a legal process. So that's your civil claims. Next is the National Redress Scheme, and I'm going to go into a lot more detail about that, but it is a more limited scheme. It's only for child survivors of institutional child sexual abuse. But one thing that's really important is that a lot of these options can be done in tandem, but another and some of them intersect in a way that taking one option will preclude survivors from actually accessing another option. And this is one. So the National Redress Scheme, if people get an outcome from that and they accept it, they do sign away their right to take any civil claim in future. So whether that's a new civil claim against the institution or reinvigorating an old one that has been settled in the past, people sign away their rights, and it's really important that people know that. The other options available to people are some internal institutional schemes. So institutions have, over the years, developed their own internal schemes for recognition and monetary and other recognition. There's many available and they vary greatly in their offerings. So I'm not going to go into that in detail, but people should know that those are available. And the last one that we've got there are the victims of crime schemes. Now, victims of crime schemes are state and territory based, and they also vary really differently in their terms of their offerings, but also in terms of their process and eligibility. They can sit alongside some of these other options, but what I will say is that legal advice on what your options are is really important in this landscape. Both in terms of what your options are, but also what the ramifications of taking up one option as opposed to another could be. And I will be talking a little bit more about that later on. So if we move on now to an overview of the National Redress Scheme. So the Australian government set up the National Redress Scheme after the Royal Commission into institutional responses to child sexual abuse. The Royal Commission went from 2013 to December 2017, and they handed down a multi-volume report which had 409 recommendations in it. One of those recommendations was a redress scheme, and that's what we have now. I would say that the final scheme isn't exactly what the Royal Commission recommended. It changed as the scheme was shaped by negotiations between the Commonwealth states and territories. So it's a little bit different to that. The scheme itself commenced on the 1st of July 2018, and it's a 10-year scheme, which means that it'll finish on the 30th of June 2028. However, people only have until 30 June 2027 to get their applications in, so it's really important to know that date. One thing, well, so we're halfway through, we're more than halfway through the scheme at the moment. One thing to note about redress is that it's not intended to be compensation. Like I said, with civil claims and civil actions, that is a true compensation option, whereas the redress is recognition of what happened to someone. And I'll go into that a little bit later. Given that we are halfway into the scheme, we have 2.5 years, approximately, a little bit more than that, for the scheme to run. There have been several reviews into the scheme. There was a 2-year review that happened after the 2 years was up. Recommendations were made for some changes in March 2021. The final government response wasn't delivered until May 2023. Some of those recommendations have been put into legislation in May this year, May 2024, and I'm going to go into those a little bit later on. But there's still continuing concerns, like Alyssa said, about the operation of the scheme. It's not perfect. I don't think that anyone would say that it is. There's also, in terms of reviews of the scheme, there's a joint standing committee that was set up to look into the operation of the scheme. That had several processes, and they've done a lot of work in feeding feedback and submissions back to government. They closed their final submissions this week, in fact, on Monday, but they've done some really good work in getting some changes happening, and no more have been instrumental in contributing to these reviews over the years. So I'm going to go into now some information about, I guess we call it eligibility. So who can apply to the redress scheme? An applicant has to have experienced sexual abuse at an institution when they were under the age of 18. They can also talk about any non-sexual abuse that was related to that sexual abuse, but people can't make an application if they didn't experience sexual abuse. We know that a lot of institutions, there was a lot of physical abuse that occurred to people, but just physical abuse happening is not grounds for making an application under this scheme. The abuse had to have happened to someone when they were a child, but also before the 1st of July 2018, which is the start date of the scheme. They have to be an Australian citizen or a permanent resident. They also have to have not had a previous court-ordered payment for that abuse. So when I spoke previously about the civil claims, some of them, not many, will go to a court and a judge will make a decision. So that's what we call a court-ordered payment. If someone has got a court-ordered payment, they're not able to apply for redress. However, if their payment under a civil claim was settled outside of court, it doesn't count as that. So people can still apply for redress if they've got a previous civil claim. The amount that they got in that civil claim will be taken into account and taken off any amount that they get under redress, but it doesn't stop people from making their application to the redress scheme. The other point of eligibility is that an institution has to have been responsible for bringing the person into contact with the perpetrator. So this is about holding institutions to account for not taking the proper precautions to stop abuse happening. So there has to be that institutional link and institutional responsibility. And the institution has to have formally joined the scheme. So in terms of the institution and what that means and who has joined, there's a very wide definition of institution in the Act, but it's typically things like schools, churches, sporting clubs, children's homes, youth detention, that sort of thing. Foster care as well, in fact. In terms of who's joined the scheme, there are all government have joined the scheme, and most churches, most schools have joined the scheme. But there are some who haven't. I will be talking a little bit later about those numbers. But it's really important that the person that the institution has joined the scheme, and there's information on the website of the scheme about that. So that's your basic eligibility for the scheme. I'm going to keep saying this throughout it, but if people are unsure whether they fit into the eligibility, it's really important to get legal advice about that, and No More's available to do that. There'll be details of how to get advice from us later on. But yeah, I think that's, yes.
I just wanted to pause on the eligibility criteria, and I suppose in some ways kind of underline, that there are a whole lot of people who don't fit into that criteria. Obviously, in terms of having experienced child sexual abuse in another environment, or following, the 2027 kind of deadline. I guess just what happens for those people in terms of recognition and compensation?
Yeah, Alyssa, I think that really highlights the limitations of the scheme and the narrow focus of it. So for people who don't fall into the time frame, there's really nothing that they can do with the scheme. In fact, they can't make that application. Their options would, so some people may have been abused in an institution but don't fall within the timeframes. They'll still have the option of taking a civil claim. They may also have the option of an internal institutional scheme and victims of crime. There has been some talk in the Joint Standing Committee and in other places about whether the scheme might be extended, but we really haven't got any indication from government that that's going to happen. So I don't think that anyone should be relying on that happening for sure. So this is your opportunity, if you are interested in redress, to find some information about that. For people who don't fall into the eligibility, other areas of the eligibility, such as they weren't abused in an institution, they may have been abused at home or outside of an institution. Their options are somewhat limited. There may be a civil claim available to them, but it would be directly against the perpetrator. That can work sometimes, but it does have its limitations and barriers. And the biggest one to that is the fact that the person that you're suing has to actually have the money to pay you. And so that is often not the case. And it's also can be difficult to get individual perpetrators to actually, participate in a legal process, especially if they don't have money to satisfy that. So look, there are definitely drawbacks here. And I think that people who find that they're not falling into the eligibility should get some advice. The other category, I guess, might be that if the institution hasn't joined the scheme, and so they need to look at the other options that they have. There are some institutions that have said they're not joining the scheme, very small number, but there are a large number who said that they've indicated that they intend to join. They're just working on doing that. So if it's, I think that people need to get advice about whether their institution has joined and what status that institution is at in the process. And it may be a matter of waiting to see whether they do fall within the scheme, making that application and waiting, which isn't an easy thing to do for people, for a survivor to sit there and not have any certainty as to what's going to happen. But yeah, that's I guess my answer, Alyssa.
Thanks, Rachel. It's a tricky question, isn't it? Of course, because we, start by saying the limitations, and I guess just to underline, the point you've just made, that redress is an incredibly challenging process for victims and survivors to be working through in terms of the level of stress, but also the trauma, the re-traumatization, that can occur through having to work through that. So it's a really challenging space. Rachel, can you make a comment there about individuals not having funds to pay for, to payouts, and that's why it's more, one of the reasons it's more challenging. We've also had questions before about institutions and payouts. Can you make any comment on that? Is that something that you can?
Most institutions will have insurance. Yeah. So that will cover them for that.
Yeah.
They may not have, for some of the institutions that are unable to join the scheme, so they're not said they're unwilling, but they're unable. We're not exactly sure why, but we're assuming that there's financial reasons for that. Yeah. But you've got a much better chance of having a successful civil claim against an institution than you do against an individual. Yeah.
Fantastic. Thanks, Rachel.
No worries. Okay, so moving on, how can people apply for redress? There's two ways. There's a paper application that can be sent to you by the scheme, or it can be downloaded from the scheme website. It can be done by hand, or there's a fillable PDF available on the website. It then needs to be printed off, and it needs to physically be sent into the scheme, which is based in Canberra. If you do a paper application, I'd suggest that people actually take a copy of it before they send it in, because otherwise, if you need a copy of it later, whether you need advice or you just want to have a record, you'll have to get a copy of that from the scheme. The other way that people can apply is through the MyGov website, and that's an online process. So that's just a snapshot there. You go to MyGov, you link the National Redress Scheme to your MyGov account, and then you can start the process. It's the same questions as in the paper form. I guess the advantage of doing it online is that you've got an online record of it, and you can always get a copy of it from online. You'll also be able to look for other documents relating to your application online as well. If you do it by paper, your MyGov account won't have a copy of your application, but if you do link your redress account, you will be able to get copies of other documents. So in terms of signing an application, there used to be the requirement that it be a statutory declaration and have a witness, but that was actually dispensed with back in COVID times. So it's no longer required, but it is an offence to make a false statement, so everything needs to be true in the application. There's all of the information that's needed is in the questions, and there's no supporting documentation that is needed. In some cases, there might be further information that the scheme asks, but they will contact the applicant or the applicant's representative and ask for that. But people don't need to get medical reports or psychiatric reports or financial reports or anything like that that you might need in a civil process in a court. So it's important to note that. So moving on to what the National Redress Scheme offers. The first one is counselling. So the counselling is brokered by states, and it's usually about 20 sessions with a trauma-informed counsellor for free that is provided. In terms of getting more counselling, people can apply to get more counselling through the government agency that brokers this, and we've had stories of people being successful in that. In some states, and I know that it happens in Queensland, there's some limited counselling available for family members of people who've accepted a redress payment, so something to keep in mind. It also includes cultural healing for Aboriginal and Torres Strait Islander people, and that's something that people should talk to the brokerage, the state government who brokers the counselling about. There's trauma-informed directories where people can access counsellors. They can also, if they have a counsellor that they've been working with for a while, rather than having to go to a new counsellor, that counsellor can apply to be on that registry, so they can continue with that same person, which is really, really important for most people. The second part of it is a direct personal response. So this is an acknowledgement. It's basically an apology that is from the institution to acknowledge that it happened and to say that they're sorry that it happened. It can be done in a wide variety of ways. The Act, the National Redress Scheme Act, says that it needs to be survivor focused, and it will be done by a letter, it can be done face to face. There's people who've asked for a commemoration plaque or a seat or a tree planted, and we've heard of a really wide variety of ways that people have got that direct personal response. I would say that the direct personal response uptake has not been as great as the scheme originally thought, and they're working hard to try and make it easier for people to get that. One of the drawbacks that some people of our clients have stated is that they're required to actually contact the institution to request that. And that can be really, really hard for people to actually go back to the institution where they were abused. So there are services that I'll talk about later who can help to people to do that. I think there's varied, responsiveness of institutions to direct personal responses. We've had really good reports from government who apologise. One example of that would be a client who was supported by our Aboriginal engagement advisors. It was the Department of Child Safety, and the department rep came to our office. This client was an Aboriginal man, and he had an Aboriginal man from the department who came and helped to organise the apology, did all the arrangements. We had food catered by a First Nations run catering company, and that was a really meaningful time for that person, that man, and he said that it was really good. I guess we've also had reports from other institutions, such as churches, who have not been as responsive and have not have acknowledged it, but have not actually apologised. So really differing experiences, but yeah, I think that it's a really personal thing as to whether people want to do that. Some people are that's what it's all about. Some people say, no, I don't want to go anywhere near the institution. And finally, the redress payment, so the monetary component, which goes from $10,000 and up to $150,000. So really important to note here that $150,000 is the absolute maximum that people can get under this scheme. If you compare that to a civil claim where there is no limit, they're very different, and the processes are very different, which is why it's important to get that legal advice. The amount is decided on an individual basis, but it's decided under a matrix about what actually happened to people. It's not ideal, but it's what was decided. So there are categories of abuse, and there are certain amounts that people get within those categories depending on what sort of institution they were in, that sort of thing. So it's not based on the impact that it had on people, whereas a civil claim will talk about this is the impact and this is what happened to me in my life that deprived me of certain things, whereas this is not that focus. It's about, was it this type of abuse? Yes, you're entitled to this sort of money.
I think,
Just,
Rachel,
yeah,
just a reflection on that's just such an important thing to understand, isn't
yeah,
it? Because I guess, both, your comments around the direct personal response, and also, the comments around the way that the monetary component is identified. I think both of those components are potentially extremely traumatizing for a victim survivor. And I think just really important, that it's understood, I suppose, so that can be really clear about that before they're entering into the scheme, because that, I imagine, one of the things that we hear all of the time, and the comments at the top of the discussion, is that those outcomes can feel very unjust.
Yes, yes. And people will see what other people in their communities are getting, and that will seem unjust. The other common, I guess, myth that people come to us with is I think it's probably on the Redress Scheme website, but in other places, they talk about the average payment that people get, and it's about $87,000. But I don't think focusing on that is useful at all, because that's not a recognition of what's happened in an individual circumstance. So it's not like, the average person who goes to the redress scheme gets that average amount. It's going to be very individual. And there is a matrix. I don't do it in these presentations because it talks about particular types of abuse, and I don't think that it's helpful. But it is available on the National Redress Scheme website, and you can get legal advice about that as well.
Thanks.
I've just got a little bit here about recent scheme data, which people might find interesting. Since the scheme started, there's been about 46,000 applications made, and 8,800 or so outcomes, with payments totaling 1.44 billion. This is as of the 9th of August. There are still 25,500 to be decided that are still being processed, and there are 6,800 applications on hold. They might be on hold because the applicant themselves wants to put it on hold. They're not sure if they want to proceed. It might also be on hold because there's extra information that the scheme needs from the applicant, and that's why it's on hold. Talked before about the institutions who've joined and who haven't. There's 44 institutions who are unable to join, and like I said, that's probably because they don't have the funds to make any payments, and 6 who've declined to join. And the website's got the National Redress Scheme website's got a good search function that will let people search their institution. But it can be complicated because institutions may have been known by different names over the years, so get legal advice if you're not clear about that. So, there's a lot of good stuff that the scheme has done over the time that it's been going, but there's still a lot to be decided and still a lot of work to do. Yeah. The next thing I'm going to talk about is some key changes that have happened recently. Like I said, there was an act passed in March 2024, which came into effect in May 2024, which has had some changes that people might be interested in. I'm focusing on this we're focusing on this in the presentation, because I think there will be people who know a lot about the scheme but who don't know about these changes. So I think it's a good idea to go through those. The amendments came out of that 2-year review that took many, many years to finally be delivered and then to be made into law. The review did conclude that significant and urgent reset of the scheme was required, and there were 38 recommendations for change. And I'm going to talk a little bit about those now. So the first one, that's probably the most significant for a lot of people, and certainly for the services who are helping people, helping survivors, is that survivors in jail are now able to apply for redress. So before this law came in this year, survivors in jail couldn't apply unless they were going to be in jail past the life of the scheme, or if there were exceptional circumstances such as that they were terminally ill. So there were a lot of people who were in jail who were waiting to be released to make their applications, but this has changed all that. So anyone from jail can apply, and the scheme has had a lot of calls from prisoners, a lot of applications received from prisoners since May. The second year review noted that this was a necessary change because they found that, or the Royal Commission found that people in jail were more likely to have experienced child sexual abuse, which had the impact of institutionalising them and criminalising them as well. So it's a really welcome change that they can now apply. So yeah, I think this is a really important part. I would say that the implementation of this change has its challenges, really big challenges. And the big one is that there are people in jail have additional barriers to accessing justice across the justice system. And this is another aspect of that. So accessing legal advice, accessing the paperwork, having a safe place to keep paperwork, being able to communicate with either a lawyer or the scheme. They're all barriers that make it more difficult for them to apply.
And Rachel, just I guess in some ways to underline that, we've excuse me, we've certainly heard the incredible demand from services who are providing that support in prisons, and to the point I think where they've had to kind of close their books and they're unable to meet that demand. Is that something that you've heard as well?
Yeah, we have. So particularly services that were working with prisoners before this change came into effect. They just have waiting lists that are really, really massive, and so it's really difficult. Yeah, so we're hoping we will continue to lobby government for additional funding for this change, and we hope that will be forthcoming, because otherwise there will be people who will miss out on getting, maybe not in applying, because people will apply on their own behalf and lodge it for themselves from jail, but they may be missing out on their full entitlements and their full knowledge of what their options are if they can't access assistance and advice. I suppose the other thing to note about people applying from prison, another barrier that's really significant, is that working through an application, especially if people are doing it by themselves and putting the details of their abuse down, it can bring up trauma. Well, I would say in all cases it does bring up trauma. And if they're in jail and they don't have that on the ground support, this can be really dangerous for people. So we do a lot of advice for prisoners, and we always try and refer them to local support if that's possible. But the other issue about prisons is that the operation of prisons varies from jurisdiction, state to state, but it also varies from prison to prison. So the support available is wildly varied, and it's really hard for services to keep up with the knowledge as to what's available. We do our best, but yeah, there's a lot of barriers here, but we and other services working in this space are really determined to work through it. It's an important change that we really welcome.
Yeah, absolutely a welcome change, and it's an incredible challenge, I guess, in something that in a process that's already incredibly challenging. And I suppose, going back to trying to really remember that this is about victims and survivors. I think it is an important part of the puzzle, isn't it, to ensure that these people who are in prisons, we know that the rates that you've talked about, can get the access to not only to the scheme, but importantly to the support.
Yeah, that's right.
Needed through the process. Yeah, thanks, Rachel. It's great to understand that.
Great, thank you. So this next change is related for people in prison. It used to be that everyone who had what they're called a serious criminal conviction, which is a head sentence of 5+ years, needed to go through a special assessment process before they could proceed to having their actual redress application processed. that special assessment process was that this separate form went to the Attorney General of the state or territory where they live in and where the offence took place, and there'd be an assessment made as to whether, if they were allowed to access redress, would this bring the scheme into disrepute or adversely affect confidence in the scheme. So everyone had to go through that process. Many people get through that process, but it does prolong the process for them. This new law, it actually limits the special assessment process to survivors who've received a jail sentence for particular offences, so unlawful killing, a sexual offence or a terrorist offence. It still means people who have got their head sentence of 5+ years have to fill in their serious criminal conviction form, but if their conviction doesn't fit within these categories, it won't then go to the Attorney General. So it will proceed straight to their application process. So what this means is that for those people, their applications won't be stalled, I guess, by that process, and they'll be able to proceed straight to redress. So we know that, again, from what I said before, there are definitely people who have got these serious criminal convictions and who will be in jail for a long time, and they were limited in terms of their access to the scheme and also their eligibility with that head sentence. So this means that we can advise people more definitively, if you like, as to whether they are likely to be able to proceed. So again, a really welcome change to the scheme from our point of view and from many people who work in this system.
Rachel, just in terms of absolutely a welcome change. It's fairly early days, I guess, but do you have a sense of, in terms of how victims and survivors have felt about that change? Is that a welcome change, for them, the people that you're working with?
Yeah, I feel that we haven't seen the real ramifications of that yet in terms of people who are coming to us, in that I don't think we've seen many decisions come back under this new law. And so I think the main thing that people would be welcoming is the advice that you will probably not have to go through that process, and so it won't take as long as it would have prior to May 2024. Yeah. Early days, like you say, Alyssa, and I hope that in a year we've got a bit more data and a bit more clarity around what this change means. And then we've got changes to the review process. So the review process is when someone receives a redress offer, they can ask, and if they're not happy with that, they can ask the redress scheme to review the offer, which means that the decision maker who made the first offer will no longer be involved. The application will go to a new decision maker and they will have a fresh look at the application. And in some cases, they might give them more money. They can give them less. That was the drawback, I guess. So the changes that have come in are that it allows survivors to provide new information with their review application. So it used to be that you can only look at what was in the original application. It allows the National Redress Scheme to request new information as part of that review process. And it does provide some protection, and a lot more than there was, against a redress payment being reduced on that review process. It makes the review process more meaningful and a lot easier. People can get a detail after their first outcome, they can get a detailed statement of reasons. And so that can give some insight into what extra information they might have been missing in their application at the start. We know that people who struggled with their initial application may not have put all of the detail in their application just because it was too hard to go back into that trauma and write it down. So this is an opportunity for people to right that wrong and to give the further information to get the best outcome possible. The way this plays out with applicants previously was that if they thought that they would get less on the review, then they weren't doing it. They weren't making the review. And many clients have said directly to me this is a threat. They're threatening me that if I go back and ask for a second look, they're going to give me less. It, in reality, didn't really work out that way. Most people were not reduced on review, but I think that just the idea that there's a threat hanging over them was really difficult. Yeah. Yeah, so I think that this is a good change as well. It's an easier way for people to do this, and it's a way that people who have made their application and over the 12 to 18 months that it's taken for it to be processed have, you know, further empowered themselves to actually give more information. It means they can now do that, whereas they previously couldn't. And the final change is not going to be in place until October 2024, but there is the chance after that comes in that reassessment can be made on some finalised applications where someone's been found ineligible. So if someone made an application and there was an institution identified that hadn't joined the scheme, and therefore they weren't found to have any monetary amount because there was no there wasn't a participating institution, they can now go back and have it reassessed if that institution has joined after it was finalised. So that will also apply if their application was finalised with that if the institution has either joined the scheme, the other circumstance is if government has actually taken responsibility for that institution since it's been finalised. So it is open to governments to be a funder of last resort for institutions, and that we're seeing that happen more and more. And so this is a chance that people can go back and get it reassessed. So they might allow survivors to have a higher redress payment if those circumstances apply. We're not entirely sure what the process will look like, whether the scheme will be contacting those survivors. We think that's what will happen, and that's certainly been hinted at by the scheme, but this will be in place and we'll be doing everything that we can to help the scheme be proactive in actually bringing this in, rather than people having to hear about this and then make the approach themselves.
That's what I was going to ask you about, Rachel, just how much we knew about the process, because obviously, you know, the process is a key part of the experience and how challenging people find. Yeah. Challenging people find it. So, but we don't know a great deal yet, it sounds like.
Yeah, I can't see that. It wouldn't make sense for there not to be some proactive actions on part of the scheme, because most people won't even have heard about this change. So yeah, we will see, but we're hoping that people will be contacted by the scheme. What that will look like if they've changed address or phone number is another issue, but you know, we'll report back later on that. Next thing I want to go through is a practical overview of the redress process. And we're going for time. Oh, we're going quickly. Okay, Lee, if we could move forward. So this is sort of a timeline of how the redress process takes. The timing of it from beginning to the end is about 12 to 18 months. So for a while there, it was 12 months. It's now blown out to about 18 months. The first step is that people submit their form, and once that is accepted by the redress scheme, they will look at the contents of it, and they'll sort of do a quality check. The first thing is that they will give a call to the applicant and do an identity check. It's called an outbound acknowledgement call. So it's really just to say, are you the person who's submitted this application? They'll also ask them for their preferences in terms of contact with the scheme. Do they want regular check-ins? How often? The other thing that can happen at this stage is that it is open when someone puts in a redress application, that they can nominate what's called a nominee. to be their spokesperson, I guess. And so they can ask that they don't be contacted directly by the scheme, and that the scheme always goes through their nominee. So that acknowledgement call will happen about 4 to 6 weeks after the application goes in. And then the next step is that the scheme will send off to the institution a request for records and to see that the person was actually at the institution. It may come back from there, excuse me. The institution may say that they don't have any records of the person being there, and we've had quite a few of these, but that they'll then have the opportunity to give their own proof of that they were there. We do see this happen quite often with schools, and people who provide school photos, school reports, that sort of thing, will get them over that. We don't recommend that people provide or try and hunt that information down at the start, because it could slow things down. But that's what that records and review process looks like. There's about an 8-week time frame that institutions have got to answer that request for records. Sometimes that needs to be extended depending on what sort of records the institution holds. From there, the final check is done, and then it goes to a separate section of the scheme to the independent decision makers. So they are independent from the scheme. They make their decision. The timing of those really varies. It can be a matter of weeks. It can be a matter of months. And then from there, once the decision is made, the person will be contacted for the outcome call. An outcome call can be done by the scheme contacting a nominee and arranging a time, or the scheme contacting the person and arranging a time to provide that outcome. It's really important that applicants know they have control over that process, that they don't have to accept an outcome call that's made out of the blue, because that can be really difficult. We've heard stories and through the Joint Select Committee, in fact, of people being called out of the blue. They're in the middle of a horse paddock, say, and the decision is made. And sometimes those decisions are not good decisions. They may be that they're not eligible. And so it's important that people, take control and say, I want it to happen at this time, so that they can have support in that process.
And Rachel, that's an important message for workers.
Yeah.
To and ensure that they're passing, sharing that information and supporting, the people that they're working with in that way, and ensuring that they know that they are able to take some control.
Yeah.
That situation, because I think, again, just going back to the process being a part of, a trauma experience, that is a great, kind of the example you've painted is a great example of that being, a pretty traumatic experience. So, I think for workers to understand they have the ability, one, to advocate, but also to make sure that the people they're working with know that they can certainly take a bit of control about that outcome call.
Yeah, and that can be set as at that beginning stage too, for people to say, no, I don't want you to contact me directly, or, I want to be able to have some control over this. If we're looking at the whole timeline here, like I said, 12 to 18 months, people who are priority. So if they have health issues, it can be sped up. If they're terminally ill, it can be done very quickly. But something that's very challenging for applicants is that in the whole 12 to 18 months, you will never be given any time frame by the scheme, because things can go wrong, I guess, or can go a bit differently depending on an individual's case. So what we try and do is to say, well, is it at stage 1? Is it at the records and review stage, the decision stage, and give broad time frames so that at least people have some idea of what could be coming. After that outcome comes out, people will have 6 months to decide what they want to do with their outcome. Do they want to accept? Do they want to say no? Do they want to ask for more time to make a decision about what they're going to do? So again, if you accept, that means you sign away your right to take any legal action against the institution. And that's why legal advice is essential. We don't want people to regret accepting their redress money and then ruling out any option that might be able to get them more money in future. Yep, so issues to note, this is the one I keep talking about, but you release the institution from any new or further civil or common law claim. You can still sue the individual, but like I said earlier, that can be a difficult thing to do. Any previous civil settlement will be deducted. I said that earlier, and there is the ability for people to get an advance payment of $10,000, and that's for people who are terminally ill, aged 55 and above if they're Aboriginal or Torres Strait Islander applicants, and 70 and above for others. So that advance payment is available for some people, and it is then taken off their redress amount at the end of that process.
Yeah, lots to kind of, lots of the fine detail in many ways, Rachel, in terms of, expectations and, clarity about understanding, how the scheme works and what that means, for the experience of victims and survivors going through it. And I presume, for you, the key message really for people is to ensure that, the people they're working with or victims and survivors have got the best advice that they can get to get the legal advice they need.
Yeah, that's right. And to have someone to advocate for them along the way as well, where possible. Yeah, so those are not necessarily major issues, but things that people really need to be aware of before going into it. The next one is a major issue that I just want to touch on, I guess, is that of ineligible outcomes. So there are definitely a lot of people who go through the whole process and wait, and then they're told that they're not eligible for the scheme. Most commonly, that's because the abuse might not fit within the definition of child sexual abuse, and the sorts of things that we see are where someone may have been strip searched, or where they may have had what was called medical examinations in the institution. So virginity testing in girls' homes was a really common thing. And certainly the girls who experience that as sexual abuse, but generally that's not fitting within the definition according to the scheme. And we are seeing, we've been seeing that pattern from the beginning of the scheme with respect to the medical examinations, but we're also seeing an increase in outcomes where the threshold of proof, so people have to, or the scheme has to have a look at the abuse that happened, and they have to say, well, it's reasonably likely that abuse occurred. And we are seeing an increase in outcomes where there's IDMs, the independent decision makers, are saying that it's not reaching that threshold. We're not quite sure why that's happening, but it is happening more. Sometimes it's also about whether the institution was responsible for bringing the perpetrator into contact with the survivor. So again, this is another reason why getting legal advice is important. And we can never, lawyers can never say absolutely whether someone is going to be eligible or not, but we can talk to people about other decisions that we've seen come through and how theirs might fit into those sorts of categories. So we try really hard to manage people's expectations and give, sometimes really hard advice about the fact that if you were subjected to virginity testing, it's probably not likely that you're going to be eligible here. But it's important that people do know that at the outset, so that it's not a shock at the end, I guess.
And Rachel, you will not be surprised to hear that, there are some, understandably pretty frustrated, angry reactions to those, to that in particular in terms of medical investigations or procedures. When we hear that, time and time again. I guess the other point just is, it's concerning that there is an increase in outcomes where, the reasonable likelihood isn't met. That's an interesting thing to understand, and, a concerning thing in some ways.
Yeah, it is. And we continue to advocate with the scheme about those decisions. And there has been some work done by the Joint Select Committee in regards to that as well. So I guess next I just want to talk a little bit about strategies that we use as lawyers to support victims and survivors through the application process. Lawyers at No More do not work in isolation. We work very closely with the other disciplines in our organisation, so counsellors and social workers, Aboriginal and Torres Strait Islander advisors, and with financial counsellors. But in terms of what lawyers do, I'm going to talk about that today. But the centre, we are collaborating on a further session where we bring in those disciplines and talk more from that perspective about how do we actually provide that emotional and cultural support for people to get through this process, as well as how we support them if that final decision is not a positive one, or even one that we might see as positive but is really difficult for them. Sometimes we see people who get the maximum amount available, but they don't see that as a positive experience for a variety of reasons. So we will deal with that in another session later on. But yeah, I guess the way that we support people at different stages in that drafting stage, so preparing of the application, we have to take some detail of the survivor's experience to provide to the scheme. And we always try and get people some counselling to support to manage their emotional distress through that. We also allow them to set the time frame for this stage. Some people want to get it done really quickly. Other people just need to take ages. And we've had clients who take years to actually get to the stage of finalising their application. Certainly, you know, many of those, while it's taken years to get through that, you know, they finally get there and they finally get an outcome, and that's a really great thing. So the application processing stage, once it's been lodged, like I said in that initial call, they've got the choice of what sort of updates they might want and whether they have that direct contact with the scheme or not. And that will really vary from person to person. Those nominees can be a really good intermediary. And a nominee might be someone like No More if we're helping in an ongoing way. It might be a redress support service, but it could be a family member or a close friend who's just assisting them through that process. So important to know that that's an option in terms of getting them through that process. And then there's the decision stage. Like I said before, be clear on the preferences for the outcome call and take control of that, because it can be a difficult stage. And it's really important that people get legal advice on the implications of what they're doing, so that they can go into that decision-making stage with a clear idea about their options. We will be, you know, No More has got a panel of civil lawyers who we'll always offer to refer people to, so that they can get some advice about what their civil option might look like in comparison to what redress might look like. And then finally, the post-acceptance stage is another time that people might need specific support. So the scheme and other redress services can help people to access direct personal response. And I think it's really important. Like I said, people sometimes don't want to go directly to the scheme. We also have at No More financial counsellors who can give advice from the very start of the process right until the end. And it's really important for people to know that they can get that. So they can advise on managing their payment. They can advise on how that might impact on any Centrelink benefits. The other thing that they can do, though, especially if it starts earlier in the stage, is that they can talk about what debts they've got and look at some debt reduction work, so that if they finally get to the end of their redress journey and they've got a monetary amount, they're at a good financial position to know what they can and can't do with that. We don't want people who get their redress amount taken from them. Debts generally can't be taken out of a redress payment, but that's why it's important to get financial counselling advice on that. Our financial counsellors have had a really good track record of debt reduction and of giving people really good support through that stage, as well as from the very start. So people can come to No More. They just have to be thinking about applying for redress, and they can access our financial counselling service. So just a few tips, I guess, on meeting client expectations. Early legal advice gives people an informed choice about their pathway. Financial counselling is important. Wills are also an important part here. So if somebody dies before their redress their redress application is finalised, the application continues and money will be paid to their estate. So much easier if someone has a will. Otherwise, it can be quite difficult to sort out. So wills are an important thing. We always say to people that there is no guarantee of a favourable outcome, but we will help them through the process. We never talk to people about what it's likely to get in terms of a monetary amount because it's really not helpful. We show people the matrix of the type of abuse and they can look at that, but we don't talk in terms of you're likely to get that. Important that people know what those timeframes are within the limits of what the scheme will actually supply. And also provide choice around the amount of support and information they need. There will be people who will lodge an application and not need anything for 18 months. There will be people who need weekly check-ins. And so that choice is a really important part of trauma-informed practice. Just that going back to the advance payment, that advance payment is not guaranteed. It's not something that someone can apply for. It's something that is offered by the scheme. And we've had a lot of clients who don't fit squarely into the criteria, but who get very distressed when they don't get that advance payment early on. And we are seeing that the advance payments are not necessarily coming through for people. The last thing I'd say is that regular health updates are really crucial in terms of whether people are priority applicants. So we're always asking people to let us know if anything goes wrong with their health, and then we can update the scheme. If someone is dealing directly with the scheme, they can do that. Certainly it will help to get things prioritised if they've got medical evidence, a letter from your doctor or something from the hospital to show what's going on with your health.
Thanks, Rachel. Just, huge amount of incredibly useful information. I suppose just the kind of the pause that's in my mind is just when you talk through I guess all of the steps, it reinforces what a process this is.
Yeah.
What a commitment, it is for victims and survivors in many ways. And there is, support and great tips and advice. But I think also, just a reminder about what a big kind of commitment, effort, investment is required from victims and survivors to be able to work through the process. It's just crystallized through all of those steps.
Yeah, it is. It's a long time for people to wait.
The importance of ensuring that the support services, which we're going to talk a little bit about now, but that are well known and well understood and easy for people to access, because obviously we want them to be able to participate in redress if that's what they choose, but we also want them to be well supported through that process.
Yeah, it's crucial. So Redress Support Services are funded by the federal government to support people through the process. We do a lot of work with Redress Support Services. If we could move on, Lee. Thanks. Supporting other workers, and that's Redress Support Services, but also other support services, sexual assault services, community legal centres. We have a dedicated team at No More who do this work and do a lot of relationship building. So we do training regularly. We have a raft of resources that we provide to people. We've got a workers support portal, which is for RSSs and other support workers who are working with survivors. We do restrict access to that somewhat. We don't want that information. We've designed those resources for a specific purpose and we don't want it to get into the wrong hands, I guess. But on that is some recorded webinars, lots of fact sheets, a manual, a whole lot of really good information, and that can be access to that, or the request to access it can be found on our website. And we also give individual support and consultation to Redress Support Services on tricky applications, checking drafted applications, all that sort of thing. So Redress Support Services are state-based, and there are also quite a few national ones as well. Some are gender-specific, some are Aboriginal and Torres Strait Islander organisations, and there are some for people with disabilities. They can help give people application drafting help. They can support them through the process and give counselling through that process, and they can help them through that end period where there's DPR, the direct personal response and counselling. There are some redress support services that are also legal services, community legal services or Aboriginal legal services, and can provide legal advice. We're the only national legal service, but those services, they're mostly based in Western Australia, but they exist as well, who are able to give people legal advice. But generally, if they're not a legal service, they send people to us for the legal advice. They're great organisations. We work really closely and in partnership with them. And you know, I think that you can find their details on the National Redress Scheme website by state or by you know, by their whether they're gender specific, that sort of thing. But they're really great services and really great workers. So I recommend people to explore that if they want support through the process from start to end.
Thanks, Rachel. And I think just to kind of emphasise that they're great services, and I also, I suppose they have lots of experience in supporting people through the process. So, you know, have a really deep understanding about the impact that the process itself can have on victims and survivors, and how to really support that through. So just really making sure that people are very well aware of the redress support services and how to access those, and certainly ensure that victims and survivors are aware of those as well.
Yeah, thanks. It's just essential, and we are so grateful for the work that Redress Support Services do in the community. Fantastic organisations.
Fantastic. Thank you so much, Rachel. That was incredibly useful, practical, you know, information to kind of talk us through both, you know, the structure of the redress, and obviously it's been around for a little while, and I'm sure many people would have a bit of a broad sense, but to really lift under the hood and get a really good sense of, you know, really the important information that people need to know in terms of, you know, going into it with very clear awareness and expectation, even around reminders that really in a formal level that this is not a compensation scheme, it's a recognition scheme. Those kinds of things I think are really important for people, you know, to understand before going in. And, you know, obviously you would be aware people wouldn't necessarily agree that that's the right way the scheme should be, and there's lots of tensions and lots of challenges, but being aware and then being able to make really informed choices about moving through, I think, is a really important part of, you know, our role and the role of other organisations as well. And I guess the other thing that was really helpful today, Rachel, is just to acknowledge and talk through some of those changes, which I think, you know, really were welcome changes. Some of them are a little bit new and kind of a bit early days in terms of understanding the impact of those. But, you know, I suppose a positive step in terms of the changes being responsive to, you know, to some of the issues that have been raised. I guess the other kind of point for me is just really to really acknowledge the anxiety that we're hearing from people regarding the firm end date of the scheme, and that it's really not that far away. You know, that is something that, you know, that kind of hard date, having a deadline, is something that I think is creating a, you know, significant amount of, you know, anxiety for victims and survivors, and those who have been considering or who are considering to now kind of have that deadline looming. So I suppose that's one of the reasons why it's important that this information, you know, kind of gets out to people. I guess any overall reflections from you, Rachel, that you want to kind of close off on?
I think it's that deadline, Alyssa. So when I started working in No More in November 2019, it seemed like it was going to be going forever, but we're getting very close to the end. We're very aware of that. We're very aware of getting the information out to people, and aware of allowing anyone who wants to know what their options are to get access to that information and access to the scheme if that's what they want to explore. So, you know, really encourage people to call a redress support service, call No More, call the National Redress Scheme to get information, or use the internet to access websites for us and other services. So yeah, I think that's it. 2.5 years will come around quickly, and we need to get this work done.
Absolutely, yeah, it will indeed. It will be before you know it. You think 2027 and think it's a long way off, but it's really not. It's around the corner. So yeah, a good reminder. I want to just formally thank you, Rachel, and thank all of our participants as well. And we do have a QR code, if I can ask you to give us a little bit of feedback around whether this has hit the mark for you and been something useful, and hopefully it has. And if you have any other suggestions for other kind of knowledge areas and learning activities you'd like to see, please do let us know. But we'd value your feedback greatly. And I want to thank you for, joining us today, and thank you, Rachel, for your time. And also, as Rachel mentioned earlier, just to signpost that we will do, we stay tuned on our socials, but we will be hosting and partnering with No More and some redress support services to really do a session that focuses very much on supporting in a trauma-informed way people working through, victims and survivors working through and going through a redress process. So stay tuned from that we'll have some great experienced people to really learn from and share their experience with us. So without further ado, I think you've got 10 or so minutes back in your calendar for the day. So hopefully that's a lovely end to the session to give you a little early mark. Thank you again to everyone for joining us, and to you as well, Rachel. Thank you.
Thank you. Bye, everyone.